So ERISA is the Employee Retirement Income Security Act. It was passed in 1974. It covers private sector employee benefits plans and government entities, churches, non-U.S. residents or non-employees such as directors and independent contractors are not covered. So churches are not covered under ERISA. We don't have to. So if you have a pension plan for some of your ministers and staffers, um, you're not obligated to comply with ERISA. It applies to basically employee benefit plans for most private sector employees. Many firms offer these benefit plans and health cares and other benefits, and ERISA's job is to make sure that the pension plans are managed well and appropriately, and that they aren't in violation of sort of good stewardship of people's money and things like that. So ERISA's language is set up as such. Section 1132, Civil Enforcement. A civil action may be brought by a participant or beneficiary to recover benefits due to him under the terms of his plan, to enforce his rights under the term of the plan, or to clarify his rights to future benefits under the terms of the plan. And Section 1140 says, interference with protected rights. It shall be unlawful for any person to discharge, fine, suspend, expel, discipline, or discriminate against an individual or beneficiary for exercising any right to which he is entitled under the provisions of an employee benefit plan, or for the purpose of interfering with the attainment of any right to which such a participant may become entitled under the plan. So you cannot, if someone is looking to get their benefits, you can't suddenly fire them, expel them, charge them, discipline them when they're trying to act within the boundaries of the statute, ERISA, to be able to secure their benefits or make a complaint if they feel like they're being discriminated against, in being offered those benefits. So Exhibit 16.9 does a nice overview of what benefit plans are covered under ERISA and which are not. So basically, retirement benefits are covered under ERISA, and non-retirement, medical, dental, life insurance, disability, et cetera, et cetera. Defined contribution plans as well as defined benefit plans. Non-ERISA plans are things like equity plans, stock ownership, cafeteria benefit plans, and IRAs and 403Bs and things like that. So if you're with TIAA CREF, which is a 403B, it is not protected under ERISA, but definitely others are. So be when you are deciding on what kind of benefits you want to offer to your employees, you should follow this chart that tells you what you're required to do and what falls under ERISA and what does not. There's some key terminology you should be aware of. Number one is an employee benefit plan is the obligation, the contractual obligation that the employer has with an employee or an organization that agrees to provide retirement benefits or welfare benefits to their employees, dependents, and beneficiaries. The retirement or pension plan provides for compensation or at retirement or deferral of income to periods beyond termination of employment. So a benefit plan is all of the benefits that we offer, including retirement benefits as well as welfare benefits like health and dental and things like that. The retirement plan, specifically your pension plan, is money that is set aside while you're working there for when you retire, so you have a deferral of income when you are retired. So you have money set aside so you can live off of that. And this is separate from things like Social Security. Defined contribution plan is a retirement plan where the benefits payable to a participant are based on the amount of contributions and earnings on those contributions. And so what we mean by a defined contribution is I agree to put in X percentage of my pay every month. That money goes into my retirement fund, and I don't know what I'm going to get out. I'm going to hope I get a good amount of money if it's invested well, and if it makes good interest and etc. But a defined contribution only is about what I'm putting into the fund, not what I'm guaranteed to get when I come out. Most employers are moving towards defined contribution. There are some that do defined benefit, but most are defined contribution. Defined benefits are where the benefit payable is defined up front by a formula, and if whatever you put in, that's what you get out at the end based on the formula. And so it's determined based on actuarial science. So the actuaries do the calculations and they figure the estimates of how long you're going to live, what your lifestyle's like, blah blah blah, and then they determine what you'll need upon retirement. So those are how those things differ. The people who administer retirement funds have a fiduciary duty to make sure that they are protecting the funds that are under their responsibility. So, fiduciary is someone who has the authority, a discretionary authority, over the investment or management of the assets. So, remember we talked in the when we talked in the chapter on unions, and unions have a fiduciary duty to make sure that they're taking the dues and they're investing them properly and they're not misspending the dues inappropriately. Same sort of thing with benefits funds. When you are investing and you give your retirement funds over to an authority, they have the fiduciary duty to make sure that they are managing your assets properly and you're making good interest on what you're doing, and it's going to be a safe investment, right? So you have to have a high level of trust between the agent who's doing the work and the employee. And those fiduciary requirements involve a loyalty to the employees. There's an exclusive purpose for what they are investing it in. They do it with prudence. They diversify the portfolio and they comply with the retirement plan provisions, whatever those retirement plan provisions are. The case in Verity Corp versus Howe, the fiduciary duty was not to mislead the plan participants. So you don't tell them that you're going to invest in a certain fund and then not do it. It is important that you're transparent, you let them know what's going on, and that they have access to the documents to know how their money is being invested. There are certain levels of reporting and disclosure that's required. It's part of those fiduciary duties. Your reporting and disclosure should include a summary plan description, so a summary of what the plan entails, where things are going to be invested, what the decision rules are going to be, et cetera, et cetera. How do you get your money out? Those sorts of things. It identifies the plan participants' eligibility for participation. Do you have to be vested in the company for a certain number of years in order to access those funds? What are the benefits under the plan? So very clearly, what can you expect in terms of the kind of benefit it is? And that has to be reported annually to the Department of Labor. The ERISA actually amended the Pension Protection Act, the PPA of 2006, after the Enron scandal. Sorry, it was amended by the Pension Plan Act of 2006 because of Enron. The participants are notified in advance of any period in which they will be prohibited from trading in their accounts. These are called blackout periods. And so what happened with Enron was people were starting to trade the stuff out of their pension funds, and they were diluting the pension fund of, of money. Participants in a defined contribution plan that invests in a publicly traded stock of their employer must be allowed to diversify their accounts into at least 3 other investment options and must be notified of such rights. And what happened with Enron is that all of the pension fund was invested in Enron. So when Enron went belly up, so did the pension fund for everybody who worked for them. So people who worked for them for 10, 15, 20 years had nothing in their retirement fund. So that was a big problem. And so now the Pension Protection Act revised this so that we can be sure that funds will be diversified and that it's not all in the employer's stocks, but it can actually be diversified into a number of different things, including the stocks of the employer. If the employer goes belly up, yeah, you're going to lose that money, but at least it's diversified in other funds, so you're not losing everything. You're only losing that portion that was with the employer that suddenly no longer is financially viable. So, who is eligible to be in a pension plan in a company? As I said, it has to do with vesting. It's the the amount of time that you need to work with a company in order to be legally entitled to receive the retirement benefit. And it varies from company to company. Typically, it's 5 years or 7 years. And it really just depends on the company and how much they want that. Like I work for the state of Illinois, it's a 7 year. I worked for another place and it was 5 years. Another place, they didn't have any limits at all. You were vested immediately. So I think it's important that you determine what is the proper time frame in which you want to have somebody vested in getting their full retirement plan or whatever they invest in it, and make sure you have that clear. And that's the part of what has to be shared with people so they know what the investment requirements are. Your benefit plans are 100% non-forfeitable after 3 years of employment. So it means that before you're fully vested, you're not going to get 100% of your money back. After you're vested, you get your money back. Um, so you're aware of that. The funding requirements for a defined benefit plan, it has to have certain minimum standards. There has to be an accrual of benefits based on service for every year that someone's in it. So you send a report out every year to know how much what their accrued benefit is, so they know what to expect upon retirement. You amortize any prior service or actuarial gains or losses on investment over a set period of time. So if there's gains, it's amortized over time. If there's losses, it's amortized over time. And the whole point about that is that you don't have one giant hit. It's sort of spread out over a period of time. The PBGC, the Pension Benefit Guaranty Corporation, basically is like the FDIC. It guarantees and provides insurance to cover any potential losses if your plan is terminated or if there's not sufficient funds to cover the promised benefit. So if you're promised $1,000 a month and the plan only has enough money for $700 a month, the PBGC covers that gap. So a lot of ERISA litigation happened after the collapse of Enron, which is why the PPA was passed. They contributed to substantial litigation involving complex ERISA issues regarding their fiduciary liability. Again, they required all of their employees to invest in a retirement fund that bought stock from Enron. And when Enron collapsed, so did their retirement fund. So that's problematic, right? And that's why PPA said, that's not okay and we can't do this. The Department of Labor has sought to broaden the definition of what it means to be a fiduciary under ERISA, making it more rigorous. The Worker, Retiree, and Employee Recovery Act amended several features of the ERISA and the PPA, and the employers are required to allow non-spousal rollovers and provide direct rollover notices as a condition of plan qualification. And the goal of this was, I would assume, was to allow for rollovers to children or perhaps to rollovers to same-sex partners where they might not be legally married. Although now people have the right to marry, but that still doesn't mean that they will. And there are a lot of people who don't engage in deciding to get married, even though they may be in a heterosexual relationship. So I think that they realize is, if people share their lives together, why shouldn't they be able to roll it over to somebody who is owed that money?